All right, I want to get this done and over with really quick because, just get this done and over with. So 620's appeal was today, and then the judge did not agree with us. I don't know if he did not agree with us or if it was just in a mood or what. But let's just break it down by the day. Got there at 10 o'clock, got there, it was actually a criminal calendar, so we were the only civil case for the court that day. They call the whole calendar. The whole calendar takes fucking 30 minutes just to call everyone to the case. About 90% of the criminals just get continued. Nonetheless, he calls us up there first thing after he goes over the calendar and says, all right, well, how long is this going to take? Proposing lender attorney says 15 minutes. This judge, they always just want to look at the attorney's counsel and stuff. I think there's a culture misconception, or maybe it's my misconception, that they're only allowed to judge, and they shouldn't be looking at pro se's as if they have any kind of input for them to take any responsibility or discernment for themselves, instead of trying to rely half on the discernment of what's getting fed to you. I don't know. Nonetheless, the substitute trustee says like, oh, well, I have so many arguments. It's probably going to be at least 30 minutes just to hear all of my arguments. And throughout the whole day, I kept hearing about, hearing. And I was like, oh, well, yeah, finally everything's going to be heard. Nonetheless, they tell us, oh, well, we're going to push you back to 2 o'clock. So you can do what you want and then come back at 2 o'clock. Come back at 2 o'clock. There's still about another 5 cases before us. They get through 2 of them and get to a break of, all right, well, let's go back to the civil case. We finally get up there. And he starts taking it one by one, because he actually read through some of the documents finally. At least the judge did, so you can get some understanding of everything. We get there. He wants to do the proper procedure. All right, well, let's go document by document, case by case. So we start at the beginning of the contingency status. All right, well, then he's like, well, let me swear you in and put you on the stand, and let's get that over first. And I was like, okay, let's do that. And we started doing that, and, I bring up the document and stuff that he didn't read and stuff, tell him the whole situation, the trap I'm in. Nonetheless, it goes through questioning about, the businesses, what I do, and I already know it's going to be an issue because, again, most businesses already have that issue. And I knew it was an issue anyways because, again, it's a rental portfolio, and the rental portfolio has issues with the clouded titles that are on them. Nonetheless, we start getting down to it. He's like, okay, well, like, what else do you make? Where's your money come from? Where's your expenses and stuff? So I had to, get down to the businesses, and then he got frustrated with the businesses of how complicated his questions weren't complicated, the answers were complicated. And I was trying to give him the full answer instead of the short answer. And then there was mic issues and my tone and voice and everything. Apparently I wasn't loud enough. The clerk kept having to, say speak up louder while I'm trying to face the judge and answer his questions, because that's my main priority of getting that straight and right. But he gets frustrated and he starts, telling me, like, I'm starting to think like you're trying to manipulate things. And I already knew, like, I just stared at him and tried to stay quiet, let him process, that judgment and statement he just made. Just for my shock too, because I knew, oh, well, this isn't going well. Nonetheless, I just try to keep the answers real short after that, to him to just figure it out. Pretty much came down to, like, even throwing out, like, look, there's 3 rental properties. I can't tell you what the mortgages are on them because the mortgages are technically 0, even though there's clouded title of the mortgages. I can't tell you, yes, it's a whole 100% mortgage, because then I'm giving you confirmation that I'm saying those are valid. I'm not saying those are valid. My number on those are 0s. That's my standing my ground on it. And I kind of got into the whole situation of the deed situation, and before we even got into the case and the merits and stuff, and trying to, like, educate him a little. And I think that's kind of where he kind of tried to take, like, me manipulating the courts instead of being able to go over all the statutes and everything that paint the picture for you. Um, so yeah, nonetheless, it came down to like, look, I have 2 properties right now, $1,500 a month. I'm saying there's 0 on there, besides the current promissory notes, and then that don't have deeds of trust. And he was like, well, if it doesn't have a deed of trust, it's not attached to the property. And I was like, again, trying to process my words, figure out how to say it clearly, because they are still attached to the property. They're material liens, and I don't want to get in the whole aspect of material liens have higher authority and rights and power than deeds of trust anyways, and the whole contract law and whatnot. But I did get into the whole point of that the loss lies where they fall. Not totally backgrounding, but I put that out there, and then I wanted to make sure, like, I had submitted also verbatim recording of this. Is this getting recorded and stuff? Because there was issues of like the interpreter being able to hear all that, to write it down or script it, or shorthand script or whatever. And I was just like, well, it's recorded, so it doesn't really matter. But nonetheless, yeah. So he tried to explain that whole situation. So nonetheless, let's try to end this, keep it short. It just doesn't go well. You know, I get off the stand for that. He says, well, I'm going to deny your indigency status. You got, you know, $1,500 a month, you know, in an income. And I'm like, I'm not even, whatever. I'm not going to rebuttal. I'm not going to argue with you right now. I already know, like, you're already in that not a good mood for me, or my side. So nonetheless, they start going through their stuff. And again, just how you'll look at my other episodes, like I debrief this, like the whole basis was like, okay, the records, getting the record straight. And I think that's why he took it, like, let's go this motion by motion. So that's what we started to do, motion by motion. So then when we got to the foreclosing parties, again, this was all de novo, how the other previous case said it was de novo. So if it's de novo, the affidavit was never submitted again. Just how I just had to resubmit everything. That was never resubmitted. And, you know, he looks to the other party and is like, yeah, I'm just going to allow that. I can't remember the specific word, but he allows it. He allows their affidavit and stuff, and nonetheless, I can't do anything. You know what I mean? Like, I already told you that's wrong, and I'm not going to argue with you. There's a couple of things, you know, I did try to clarify on. Yeah, so I didn't want to end up arguing with them. So I was like, the last thing I want to do is start any kind of argument tone with the judge. I already know, I already messed that up somehow with him thinking or feeling, obviously feeling, because you can hear it in his tone, and that tone is obviously well, obviously it's an indicator, but it's a release from holding it back. You know what I mean? There's other ways to do that, and I think that's what he kind of did when he was sitting on the bench. So I understand there was a lot of pressure on this, even on their side, as much as, you know, they stuck with what they're comfortable with, procedure-wise, with foreclosures and appeals on foreclosures. Yeah, so I got off the bench, and then he starts going through it, and he starts going through, not ruling on anything. He obviously rules on any of my objections, you know, the affidavit not being actual authentication, it being hearsay, being Rule 403. I think I shied away from saying Rule 403 because I didn't pull it up real quick. Nonetheless, it's still hearsay, and the base that the witness is not there to cross examine it normally gets thrown out in most civil situations. The issue is that the whole Chapter 45, everything's got to get seen under Chapter 45, and it's like, okay, well, let's squash that under Chapter 45, Section D, blah, blah, blah. Specifically states other evidence or applicable laws. Well, guess what? All these statutes I keep saying about holder, in due course, they're all laws. And again, I didn't base anything on the contract law, but even then, on the stand for the indigency status, I said, like, look, this is, losses lie where they fall. They're the ones that didn't hold the notes, the original note, the document, the cash, the currency, properly. And now all they have is copies and copies and copies and hearsay of he said, she said, of I gave it to this person, they gave it to me, and they gave it to that person. No, that's why you can't have he said, she said. It's bifurcation. And again, a lot of their heads probably don't even understand what that word means. And it's like, I should not be sitting in this jurisdiction if no one in this room understands what bifurcation means. Because even for you to understand what bifurcation means, it means you understand what holder and due course is. And then if you understand what those two means, you understand what those are attached to. Negotiable instruments. The contract is still a negotiable instrument. It can be a non-negotiable. It can be a negotiable. There's different things, and it's more than just what's on there. It's how it was dealt with. These aren't lenders; they're debt buyers, and I made sure to bring that up and whatnot. My main objective was going through the main points, making sure the motion to dismiss was on the record so that it's all there. I don't think he even submitted the motion to dismiss. So that's why I'm going to have to go get that verbatim auto recording so that I can actually go like, look, this is all the back and forth the judge did just doing this appeal. Like, look, you can't have it both ways for their party. There's a few things that they wanted it both ways for their party. Oh, well, you have to take relaxedness of the non-judicial proceeding and the affidavit and the evidence and stuff. What do you mean? Here's the little half of a sentence in chapter 45, and here's the other case law that I brought up and mentioned saying that it must be seen with scrutiny and jealousy. That's the opposite. And if you look at due process, the same thing. The fairness of both sides have to take into account. While I understand the non-judicial process and stuff have expedited the speed of lenders or debt buyers, it doesn't stop the due process of, wait, is this valid? Are there other statutes heard? I think the judge was pretty much sitting in the original merits of the everything else previously in the non-judicial hearing not getting heard. Raccoons and cones falling on me. Nonetheless, so it goes down to like, well, if everything I said to that day or today, you didn't pretty much listen to anything, then you didn't take anything into account. And I asked for a couple of clarifications on a couple of specific things. And again, he just says tonight, here's my ruling on everything. So yeah, there's nothing I can really kind of say. I understand where he was at. I understand everything I was previously saying. But now you can kind of see it. Like, I'm going to get this recording. You'll see in the recording. Like, I even got stopped in the parking lot by other people. Obviously, they were also pro se. But when you have the whole courtroom or whatever's left of the courtroom at the end of the day come up to you, it shows you, like, yeah, everyone in the courtroom saw the judge's emotion. I kind of saw it earlier in that day anyways. I was like, well, this is the district main judge. So it's like, yeah, so it's... I thought he would have been a lot more fair, but I think it just went back down to, like, I think he stepped to the ground or stayed on the side of not being able to hear everything as anything because it was all in an LLC and whatnot. And I think I'm making that conclusion because of how he ended it. When he ended it, and this is kind of where it's like, I already went in there and, I've already been through a few of these. Let them do whatever they let it be. Like, record at least, though, so that you can eventually pull everything out from them. Like, hopefully every step you go to, it stops there. But I understand, like, it's a lot to digest. And you can hear it from the judge's closing statement on the order. He started saying, I was the fraud one. Whoa. Again, you can't have it both ways. Like, and in the middle, he also said it both ways. He was like, well, if you quit claim deed to you, you have all the interest in the everything. And again, I just stay quiet. I'm not going to argue with him. Like, and that's what his main thing was doing all day. And I think that's why I picked up on it. He would not give any other, like, not even, all right, we're case closed or like next or anything. Like, he would just, okay, here's this, and then stop. And then wait until the attorneys move things or do stuff. So yeah, that's where I come to that conclusion. And it was a big issue because there was an earlier case, like, he was slapping him with 10 years, like, this guy. And like, he just had some question that I was asking him about, oh, when was the last time you had drugs, alcohol, blah, blah, blah. Again, these are all criminal cases that we're hearing today. So I don't know the whole story of, like, why it took him a minute to answer. But like, you can answer anything. Like, I had alcohol on Thursday. Now, if his probation doesn't allow that, then yeah, then it's going to be an issue and stuff. But he had an attorney there with him. So like, he should have just been asking his attorney, and he kind of was in the middle, but again, the judge got upset because he was thinking like, why are you taking too long to answer? You're trying to manipulate the court or trying to pull one over me or whatnot. And it's like, no, I understand what that guy's in. Like, he's getting 10 years of prison that he's got to deal with. This is all civil I'm dealing with, and I understand the weight of it. I was in the back of the room trying to breathe, sweat chills all day. Yeah, so, fuck. But everything's recorded now. So from that recording, again, we got to take it to the next chain of command up. Just to point on the two double-sided again, midway, he was like, well, if I'm not going to rebuttal and like say, well, if I hold all interest, then I can rebuttal everything for that LLC too. But no, hold, I told him like, I'm not here to rebuttal any merits of the loan, the LLC, the documents, or anything. I'm just here to look at the statute and apply the statute of what wasn't met. The holder in due course, admissible evidence, civil procedure. And if you have questionable about, well, if this is going to hold in civil procedure, if civil procedure applies, we're in an appeal case. This is full civil procedure jurisdiction. Now, whether the Chapter 45 applies civil procedure, I don't think it's quasi jurisdictional in the non-judicial proceeding, but once it's in the appeal, the full judicial, again, like proceeding, that's what civil procedure statutes say. It says it applies to all proceedings, which I think it applies to non-judicial proceedings because, again, it's in the fucking title, proceeding. But there's been many attorneys that have used some other case laws that says, oh, well, this should be relaxed because the whole point is to give lenders easeability to recover their loans and payments. And it's like, that's why I brought up, these guys are not lenders. These are debt buyers. There's totally different rights, equitables, and definitions that surround that and how you actually transact those documents. And that's where I can reiterate it, holder in due course. I even asked the people in the elevator when we were going down because they brought it up. I go down there and they're like, yeah, I'm just getting hound, but does it make sense? Like, was it clear? Because that was my main, like, issues. Like, oh, well, I'm going to hand you this motion to dismiss again because it's all written down in here, but here's my terrible fucking wording of everything. From that terrible wording, everything is like, I think my tone was good. And if you look at the first 620 hearing case, which was a different judge, which was the judge, if you look at 511's last debrief, was that judge, which he's the one that stated, 511's judge was the one that stated, well, I don't see the affidavit. You're going to have to resubmit it again. And that's where I brought it up to this judge for 620. Like, judge, there's no affidavit. Like, if we want to start getting strict and scrutiny on everything, it's got to play for both sides. Like, there's no affidavit. Like, we started with the whole procedure. Like, you were about to kick out my indigency petition and submission for hard proof because it was before the appeal submittal. So, like, same thing. All their affidavit evidence, how the other judge for 511 stated, has to get resubmitted. It's not on the record. And even today, when I tried to I submitted a few weeks ago, submitted the land record, they said, well, that's rejected. That's gone. Like, no, because it's got to be calendared. So yeah, it goes down to like, well, I still got to go look up how to calendar something. The whole submitting of the file and the certificates of service and stuff and sending it to people. Well, I just wasted fucking $400 on a whole bunch of certificate of service because it's all, nope, not right timing, not the right procedure, not the right calendaring, blah, 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 communication. Who knows? But again, the whole point of civil procedure, and this was from Harvard University, I just recently took one of their contract law classes, states specifically the whole beginning of civil was the purpose of a civilian to be able to understand and process and do everything. Well, even though I don't think I'm a great talker. I know procedure-wise, paper-wise, I was at least decent. Talking at least decent enough for the audience in the courtroom to the other civilians to also understand these complex situations, that I was able to clearly state it enough so that they understood it. They agreed with me. So I have no issue taking this to a trial. Like, look, the criminal people in the room agree. I understand the lawyers on the other sides have a financial fiduciary responsibility. I was really hoping that they would just fall short and not show up today. But again, they're getting a $500,000 property for $10,000 is what they paid for on public record, the evidence, which again showed the judge, like, look, I'm not here contesting anything. Like, even if you don't submit the land record or any other evidence, it shows in their affidavit. It's all stated in the deed of trust. Nowhere does it state that the note was transferred, and no authority between that chain of title of that note was ever documented or evidence submitted. And if you won't let me submit the land record, but you'll let them submit the 2 deeds of trust, and not the other 8 deeds of trust on the record that show something else and paint something else, well, judge, I don't know what to fucking tell you. Like, seriously, like, I don't know how much clearer I could have fucking made it. And I think he knew that. I think, again, he was just leaning into, oh, this was an LLC, blah, blah, blah. None of the stands or holds. And because of how he ended it saying, oh, well, the judgment order is blah, blah, blah. Along the line, something around like, I'm the fraudulent one. I fraudulently induced title loans. And this was my plan the whole time. It's like, no. I understand you had previous knowledge in the petition agency of the other different properties and stuff, but this whole, again, you can't have it both ways. You got to make your grounds and circle of this case and stay and you can't, as a judge, just go in and out whenever you please, and then just pick whenever the other side wants you to stay on their side. I'm not trying to, waste sides of, which way did you lean more, that way, that way. No, it was pretty fucking clear. It was clear enough that everyone in the audience, like, yeah, multiple. Nonetheless, I still got to go fucking deal with it. Yeah,